Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about an issue that has been raised at the United States Supreme Court called equitable mootness. It's a strange term, but let's discuss it down at the beach. If you were to sue Walmart in federal court and you got a judge who made a number of errors in that trial, you have an absolute right under the United States Code to appeal to the Circuit Court of Appeals that controls that court. So, for example, in Kansas City, if you were to sue in the Kansas City federal court, you could appeal to the 8th United States Circuit Court of Appeals, and that appeal would be heard as a matter of right. That is the way the world is supposed to work in federal court. U.S. Bank has raised an issue of equitable mootness, and equitable mootness comes about as a result of the rather strange way that bankruptcy courts are impaneled. As I have mentioned earlier in a video where I talk about where the federal judges come from, and if I can remember, I'll link it up here, the bankruptcy judges are appointed by the Circuit Court of Appeals in their district. They're not presidentially appointed. They are not Article 3 judges. In fact, they are called Article 1 judges because bankruptcy is a feature or a creature of statute. Bankruptcy is governed by rules that Congress sets, and so they are considered to be Article 1 judges. They do not need to be appointed by the president or confirmed by the Senate. Several years back, however, there arose an issue where essentially the Supreme Court said, now wait a minute, we can't have people exercising judicial power under the Constitution that do not have Article 3 privileges. And a bankruptcy judge is not an Article 3 judge. So what happened was the bankruptcy courts were restructured. And that restructuring put them beneath the district court in the district where they operate. So, for example, the bankruptcy court in Kansas City, Missouri, is a component of the district court in Kansas City, Missouri. When they did that, they altered the manner in which bankruptcy appeals were taken. As a matter of right, you have the right in bankruptcy to appeal to the district court. Then if the district court believes the bankruptcy judge made an error, he can order it reversed, and that works. In the event you disagree with the district court, you have a right to appeal that decision to the Circuit Court of Appeals. That's the way it was designed to work, but that is not the way that it is working. In bankruptcy, there are several different chapters of bankruptcy. Chapter 7 is an individual bankruptcy where essentially everything is wiped out. You take all the debts and you pay off the debts with whatever property and assets can be sold. Chapter 13 is the wage earner plan, where essentially they gather up all of an individual's debts and they set up a payment plan over 3 to 5 years that pays off as much as possible those debts, and then at the end of that time they get a discharge and they have no more debt. Same thing with Chapter 7. When that process completes, the person is debt-free. Chapter 11 is a little different, and it's designed to assist companies. And basically what Chapter 11 does is it allows a company to reorganize its debt. Now, if that sounds like you're just putting it in different drawers, it's not the way it works. Basically, the company has to take steps to pay off the creditors that it has at some level. Probably it can be as low as 30 cents on the dollar, sometimes 20 cents on the dollar. But it makes an effort to pay off individual creditors so that it can get sort of a new lease on life. Sometimes in Chapter 11, the entire entity, the entire business is sold to a competitor. And as a result, many of the creditors of the former business get paid, if not in full, at least as close to in full as possible. Indeed, anybody that has a judgment or a security interest in property is usually paid in full. Unsecured creditors and people like stockholders often wind up getting mere pennies on the dollar, and stockholders usually get nothing. Usually stockholders are wiped out when a company takes bankruptcy. Not always, but frequently. So U.S. Bank was a claimant in a bankruptcy. The company had a rather unique structure. It had originally been one company, then it split itself into two companies, assigning one company the debt and the other company the assets, as I understand it. And then it took bankruptcy. And as a result, companies like U.S. Bank, which held a large amount of the debt, were adversely affected. So what has to happen in a Chapter 11 is the debtor has to come up with a plan to get a confirmed discharge. It's called the confirmation plan. It holds a long and involved hearing, the court does, on that issue. And then at the end, it either decides to confirm the plan or send them back to the drawing board. Creditors like U.S. Bank have the right to object to the confirmation plan and make their objections known at the hearing. And indeed, that's what happened. In spite of those objections, the bankruptcy court issued its confirmation order. In spite of the objections, the bankruptcy court issued a confirmation order. U.S. Bank immediately appealed, and when it could not get its appeal heard on an expedited basis, it moved for a stay, which would have temporarily halted the proceedings. The bankruptcy court denied the stay. The district court never ruled on the stay. About a year later, it said, "We are not going to grant your stay, and I'm going to affirm the bankruptcy court." So U.S. Bank went to the Circuit Court of Appeals, and the Circuit Court of Appeals essentially said, hey, look, there's a confirmation plan. All these people have made, changes. They've bought assets. They've sold assets on the basis of this confirmation plan, and I don't know how we unscramble this egg. So under the doctrine of equitable mootness, because you didn't get a stay, which, by the way, wasn't their fault, because you didn't get a stay and you didn't stop things in its tracks, well, it's equitably moot and we can't help you. So in a very well-written, well-drafted petition for certiorari, U.S. Bank has taken to the Supreme Court the issue of, is there actually judicial review of bankruptcy opinions and bankruptcy decisions? A copy of the actual petition from the U.S. Bank National Association versus Windstream Holdings. And here are what the counsel for the bank claims to be the questions presented. It says the judge-made doctrine of equitable mootness allows Article 3 courts to shirk their bankruptcy oversight duties as mandated by this court in Northern Pipeline. A court can decline to exercise its jurisdiction to review the legality of a consummated bankruptcy reorganization plan if the court somehow determines that it would be inequitable to disturb the plan, regardless of whether such plan is unlawful. The doctrine has no common law, statutory, or constitutional basis, contradicts the Bankruptcy Code's language, overrides this court's directive that Article 3 courts have an unflagging duty to exercise their jurisdiction, undermines fundamental principles of separation of powers, and is prone to abuse. Other than that, you understand it's fine. So the questions presented are, does the lack of a statutory or constitutional basis combined with its demonstrated potential for abuse require it to be abolished? I would say the answer to that question should be yes. Does the Second Circuit's rule that an appeal from a substantially consummated plan is automatically equitably moot if the appellant did not pursue a stay, regardless of a stay's availability or any other equitable factors, undermine any prudential purpose for the doctrine? And again, I think the answer there is absolutely. Say, look, Congress's comprehensive statutory scheme for bankruptcy cases establishes specific parameters for original and appellate jurisdiction. It does not include any provision that could be construed as granting the court's discretion not to exercise that jurisdiction based on equitable or fairness considerations. The doctrine of equitable mootness has been made and fashioned by the courts from whole cloth, is based on the court's speculation about financial markets needing certainty regarding bankruptcy transaction, and has been unevenly applied by the various circuits. And I think the record certainly reflects that. The harm caused by the doctrine is very real given the billions of dollars that flow to today's Article I bankruptcy system. The magnitude of the abuse made possible by the doctrine is amply illustrated here, where erroneous rulings of the bankruptcy court have been permitted to stand because they were shielded from appellate review. Legal error that can be remedied has been instead allowed to stand, depriving petitioner and holders of more than $1 billion of unsecured notes it represents of the rights of bankruptcy code provides them. And I would add that in the bankruptcy case that I was involved in, the bankruptcy judge simply ignored a Supreme Court case directly on point and approved things that were clearly not subject to approval under Supreme Court precedent issued in 2020. So it looks to me, from the outside looking in, that the bankruptcy courts have some real issues and that the district courts have essentially been running cover for them. I can tell you that when I was involved in a Chapter 11 bankruptcy against a company and I objected to the confirmation plan, I could not get my appeals heard in a timely manner by the district court. And eventually they were all equitably moot. And our bankruptcy counsel advised us not to pursue them further because, again, for the most part, there was no way that a circuit court of appeals with the precedent that's out there is going to unscramble this egg. But there is a huge problem with this. First of all, this is not a matter of statute. In other words, there's no statute that says things become equitably moot. In fact, there's a statute that guarantees you the right to an appeal through the federal court system. But courts aren't honoring that. And indeed, the Supreme Court has, in numerous instances, told district courts and circuit courts of appeal that they have an unflagging obligation to exercise their jurisdiction. So if they exercise their jurisdiction by not exercising their jurisdiction, that is ridiculous. And that is essentially what this doctrine of equitable mootness means. It means it's just too hard to unscramble the egg. In my view, there are two solutions to this. One of them is that whenever an appeal is taken, the district court ought to have about 15 to 30 days to decide that appeal. And if it cannot decide the appeal in that period of time, then it should issue a stay. Because every litigant is entitled to have their day in court and their issues determined by a federal judge, and that's not happening. The Supreme Court could mandate that by rule. Congress could mandate that by statute. And in that way, you could get around this equitable mootness issue. Now, what people are going to say about that is that it's not fair. And the reason that it's not fair is because you tie up this company for months and months. Well, when you tie up that company, there could be a loss of value. I would agree with that. And it would certainly make it more likely than not that customers and maybe even employees would jump ship. But then again, it wasn't the customers or the employees necessarily who put the company into bankruptcy. Most of the time, it was the senior management of the company that put it into bankruptcy. And if anybody is to bear responsibility for there not being a confirmed plan, it should be the people who essentially use the bankruptcy court as a way to, in my personal opinion, defraud creditors. And that's what's happening. Anytime, for example, Johnson & Johnson spun off one of its entities into two and said, one of you is going to hold the debt and the other one's going to hold the assets. And, we'll give the company that holds the debt, $150 million to pay billions of dollars in debt. And the Third Circuit Court of Appeals said, not so fast. We're not going to let that happen. I think that was a good decision. But again, when you do things like that specifically to benefit your stockholders and your company and disadvantage a specific group of creditors, you should not be able to get away with that. And as a result, the Third Circuit said, sorry, we're not going to let that happen. To make a long story short, this is an important case, and we'll have to see if the Supreme Court takes it. I think that particularly given the nature of the case below and the way it was handled by the bankruptcy court, as well as the way it was handled by the district court, I think there is a good chance that the Supreme Court will step up here and make a determination once and for all that equitable mootness is neither mootness nor is it equitable or fair, because it does deprive somebody of their day in court. As this moves forward, I will try and keep you posted on it. We'll find out if the Supreme Court takes this in somewhere between 90 and 120 days. And I'll keep you posted. Thank you so much for watching. If you have any questions, leave them in the comments down below. Like, share, subscribe. You know the stuff we ask you to do. If you have the opportunity today, take a moment and do something nice for somebody. Say something nice to your spouse. Tell them that you like the way they look. Anything that makes somebody else's day better inevitably makes your day better too. We'll catch you down here at the beach next time. Thanks, guys. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.